I'd like to thank everyone for coming today. Last week of classes, chaotic time of the semester. Really appreciate everybody coming. Would also like to thank Professor Margaret Moses. You were very instrumental in bringing Mr. Martinez-Fraga here today, so thank you very much for all your work in this coordination. I'm Athanasios, one of the co-presidents of ILS.
I'm Natasha, the other co-president.
And without further ado, we're going to introduce Mr. Martinez-Fraga a little bit. So Mr. Pedro Martinez-Fraga is a world-renowned international legal scholar and arbitrator. He has served as lead counsel in international disputes to 10 sovereign states, was appointed by President Barack Obama to the ICSID, the World Bank, panel of conciliators as a U.S. delegate, and in August of 2023, delivered the special course on private international law at the Hague Academy of International Law. Mr. Martinez-Fraga has been invited to lecture at the pardon my pronunciation, but the Xiamen Academy of International Law in this summer and the People's Republic of China.
Mr. Martinez-Fraga in April of 2022 was appointed to the Executive Council of the American Society of International Law, from which many of us are returning just last night. And he currently serves on the awards committee of the Madrid International Arbitration Executive Committee, called the SIAC, of the Singapore International Center, to serve as a member of the SIAC panel of arbitrators. Additionally, Mr. Fraga is listed as counsel to many who may be appointed to represent victims or the accused in cases before the International Criminal Court at The Hague. He has served as an NYU scholar in residence, distinguished visiting practitioner of the international law at NYU, and taught and lectured at over 62 law schools generally. Without further ado, and with much excitement, Mr. Martinez.
Okay, right. Let me click it right now. I think I this out of the way. Yeah, thanks. Well, first of all, thank you. Thank you for that introduction. A lot of that stuff is just marketing, so don't pay any attention to it. I want to thank you, first of all, for inviting me here. It's a real privilege to meet you. I've heard a lot about all of you, really. And I want to thank Professor Margaret Moses. You know, she is a real gem that this law school has. And she's far beyond the law school. She's a gem nationally and globally. She teaches all of us. So she's our mentor, our teacher, our friend. And I can't say how lucky all of you are to have had her with you, and how lucky this institution is to have her and to have had her all of these years. So Professor Moses, thank you for this opportunity, and thank you for your passion. I want to talk to you about promises that have not been kept, and I'll keep my eye on the clock to make sure that I keep my promise of only an hour and 15 minutes or so. A poem, I think, is necessary, and this is a citation from Robert Frost. Whose woods these are, I think I know. His house is in the village, though. He will not see me stopping here to watch his woods fill up with snow. My little horse must think it queer to stop without a farmhouse near, between the woods and frozen lake, the darkest evening of the year. He gives his harness bells a shake to ask if there is some mistake. The only other sounds the sweep of easy wind and downy flake. The woods are lovely, dark and deep, but I have promises to keep and miles to go before I sleep, and miles to go before I sleep. Robert Frost's lonely traveler resists the seductive and compelling invitation of the lovely woods to take a detour from what appears to be a forced march in the middle of winter. He does so in order to fulfill a promise the lone traveler believes must be kept, notwithstanding the allure of the inviting woods. The promise, of course, is not disclosed. The poet wants the reader to understand the promise as generically as possible, free from any taint of particularity that may otherwise cloud our thinking. The lonely traveler is redeeming the very concept of a promise itself. The image invariably leads the reader to wonder, why do we collectively, as human beings, at all break rather than keep promises? Obviously, there is no single answer to the query, which itself suggests the multiple answers likely are as complex as the nature of human beings and promises themselves. International commercial arbitration is a dispute resolution mechanism that purports to be the dispute resolution or legal counterpart to economic globalization, has advanced a very daring promise upon which its very legitimacy and workings now rest. ICA, as I call it now, has promised efficiency. And the very name of efficiency has sacrificed, and in the very name of efficiency, has sacrificed the very sacrosanct principles, not the least of which is second instance review, among many others. So compelling is efficiency within the ICA framework. The promise, however, raises more questions than perhaps the promise itself can ever venture to answer. By way of example, is it possible for ICA to be efficient if only a small percentage of cases settle? Think about that. Is settlement the proper teleology of ICA? If the answer to this second query is in the negative, how then is merits-based adjudication more in keeping with the ICA core principle of party autonomy, instead of resolution pursuant to a settlement by mutual accord? Is that even conceptually possible, I ask you? Is there a principle, a main reason or root cause that ICA settlements constitute the exception and not the rule? Assuming there is such a principal reason or root cause, can it be identified and addressed? Equally pressing is the extent to which ICA can be rendered more susceptible to settlements within its existing rubric. More plainly, if in fact there is a discernible principle, overarching reason that tends to preclude settlements in ICA, as opposed to, for example, judicial proceedings in a number of US jurisdictions, can this deficit be addressed without altogether radically altering the nature of ICA itself? Will it denaturalize ICA if somehow we attempt to foster settlement within this framework? It follows that because arbitral disputes are not most commonly settled, they necessarily proceed to a merits-based adjudication. But we haven't thought much about what it means to proceed to a merits-based adjudication as a community of ICA stakeholders, adjudicators, lawyers, academics, and purchasers of these services. In this lecture, I would like to invite you to consider adopting the assumption that merits-based adjudications are time-consuming and inefficient. And I know that's an assumption, but for purposes of this thought experiment, I ask you to please bear with me. Moreover, they necessarily take the form of a zero-sum game, meaning that there is a prevailing party and a non-prevailing party. And that is, ladies and gentlemen, a euphemism for a winner and a loser. This was the late Dean Lester Thoreau, Dean of the Sloan School at MIT. His concept that if there's a winner or a loser, this is a zero-sum scenario. Of course, he was applying it in an economic context, also in a social political context. The proposition that merits-based adjudications are not preferable to settlement itself can be viewed as hardly conclusive and intuitive, and little more than an untested assumption that is subject to discursive reasoning and which leads to diametrically opposite conclusions. Certainly, it can be forcefully asserted that parties to a contract are entitled to nothing less than a merits-based determination that rewards the prevailing party, i.e. the non-breaching stakeholder, by placing that stakeholder in the position that she was in prior to the breach, or otherwise with the entitlement to lost profits arising from non-compliance. The specter of specific performance may also loom as an attractive measure of remedies to be attained. Hence, so the argument says, ICA's genuine teleology is a merits-based adjudication, where damages are established and awarded to the prevailing party. Indeed, this proposition further contends that nothing short of a merits-based adjudication was contemplated by the stakeholders at the time the relevant arbitration clause was first, presumably negotiated, and second, drafted in its final iteration. This assertion also states that, quote, a settlement by definition is a, quote, compromise that deprives the non-breaching party of its right to be made whole based upon economic models of risk assessment and costs that have nothing to do with the actual facts underlying the particular dispute at issue. The question of whether a merits-based adjudication is preferable to a settlement shall pervade this talk. It will be looming in an invisible and silent background, but ever present. The assumption upon which our journey, however, is based is that settlements are more efficient and therefore less expensive to the stakeholders than a merits-based adjudication that takes place approximately 3 years after a request for arbitration was filed and yielding a, quote, all or nothing result at the end of this time frame. Moreover, it is further asserted that notwithstanding the efficiencies endemic to the absence of second instance plenary review, the proliferation of New York Convention stakeholders, and the narrow grounds for setting aside an award set forth in modern and national arbitration laws, and the conclusion of a final hearing and subsequent issuance of an award, the execution phase merely commences. It is the beginning of an end to the beginning, to be sure. Here as well, time and resources will be consumed without necessarily a promise that the award shall be satisfied. Please bear in mind that we are not factoring into the time and resources equation complexities and problems that inevitably would be compounded and multiplied by counterclaims and multi-party arbitrations. Let's leave that to one side. Things are difficult enough as they now exist. Accepting the premise that settlements are more efficient than merits-based adjudications, it necessarily follows that ICA has failed to keep and to redeem its promise to be an efficient cross-border dispute resolution methodology. This difficulty is made worse because conciliation and mediation only constitute a perfunctory role in the actual culture of ICA, notwithstanding parallel mediation rules offered by many of the leading arbitral institutes and recent guides on facilitating settlement and international arbitration, published as recently as July 2023. Indeed, the International Court of Arbitration of the International Chamber of Commerce, the ICC we all know and love, more specifically, the ICC's Commission on Arbitration and ADR, just very, very recently, more or less, in July 2023, launched guides on effective conflict management and facilitating settlement in international arbitration. The publication of facilitating settlement in international arbitration observes that the historic role of arbitrators, quote, in most jurisdictions has been that the role of the arbitral tribunal is to decide to decide the case in an enforceable award, end of citation. It adds that in keeping with this understanding of arbitrator objectives, quote, the parties remain free to negotiate and settle their dispute should they wish to do so. But that was not something the arbitral tribunal should seek to encourage, facilitate, least of all, become directly involved with. This view was motivated by concerns that taking on such a role would negatively impact the tribunal's neutrality vis-a-vis the merits of the dispute or the party's perception of it. End of citation. The ICC's Commission on Arbitration IDR further observed in the introduction of the facilitating settlement in international arbitration guidelines that, quote, the debate has now moved from whether arbitrators and arbitral institutions should take steps to facilitate settlement to how that should be done, end of citation. This publication, of course, is a modest step in the right direction. In fact, the publication itself contains the disclaimer that the views contained, quote, should not be thought to represent the views and recommendations of the ICC International Court of Arbitration or the ICC International Center for ADR, nor are they in any way binding on either body, period, end of citation. Addressing the question of settlement in ICA, however, will require more than just educating arbitrators in most jurisdictions, on helpful settlement facilitation techniques. Much more is necessary. Structural procedural amendments, together with the development of new arbitral culture, shall be necessary. The task, quite frankly, is daunting. I will now share with you a second proposition that you are invited to accept as true. It may seem as heretical as the principle that settlements are more favorable to arbitral parties than merits adjudication. The inevitable question arises, is there a principal reason why ICA cases do not settle with greater regularity? Why don't they? Perhaps more precisely stated, why is it that in some jurisdictions, most notably the United States, but Switzerland as well, I share with you, an overwhelming percentage of civil cases settle, while in ICA, the diametrically opposite proposition holds true. The vast majority of ICA proceedings do not settle. Certainly, even generally speaking, there are multiple legitimate reasons why such is the case. Arbitrators are not trained to encourage settlement, and only recently in the 2021 ICC arbitration rules was the wording of Appendix 4 changed from merely, quote, informing parties that they were free to settle their disputes to arbitrators empowered to, quote, encourage the parties to consider settlement, end of citation. And the culture of arbitration generally does not emphasize settlement in its foundational arbitration rules. Indeed, in almost all of the major institutional arbitration rules, the term settlement does not appear at all, or hardly is even referenced. In ICA, mediation is not compulsory, and any settlement effort using the best placed settlement facilitator, the arbitral tribunal itself, necessarily would have to navigate considerable ethical challenges, which certainly are manageable, but also are quite significant, almost like walking around raindrops. In this talk, I will ask you to assume that a settlement of a dispute is not possible and certainly not likely unless and until the stakeholders have been able, one, to identify, second, to quantify materially and comprehensively their respective risk in proceeding to a final hearing. This is important. You have to identify risk, quantify risk, and communicate risk. And what I am sharing with you is the thought that unless these three principles take place, meaningful settlement does not happen. And these three principles don't take place, and certainly do not take place on a timely basis in the majority of ICA cases. And for that reason, I share with you, I believe ICA cases do not settle. ICA cases do not settle largely because risk assessment either is not possible or mostly is not viable until a procedural juncture when it is simply too late to settle. Why then is such the case? I advance for your consideration the suggestion that that the ICA evidence taking and evidence presentation framework, in addition altogether to omitting compulsory mediation early or throughout the process, simply is plagued with too many uncertainties. These, quote, uncertainties lead to lack of transparency. And that's the problem. As will be more fully discussed, the arbitration rules of all major arbitral institutes dedicate all but a few paragraphs, generously assessed, to evidence taking and presenting. The de facto effect is to minimize ICA's foundational principle of party autonomy in favor of arbitrator discretion. Let's stop here for a second. I also want to bring to your attention that, in my view, international arbitration, whether ISDS or ICA, investor-state settlement disputes, investor-state arbitrations based, of course, on treaty, and ICA are a battle, if you will, to use that term, between party autonomy and arbitrator discretion. It can, at the end of the day, be reduced to that tension. And the parties want to make sure that their autonomy prevails. But the workings, framework, and structure of both ICA and ISDS are such that it's very close. And I dare say, more often than not, if you view it through the lenses of the tension between party autonomy and arbitrator discretion prevails. The latter principle, however, this is party autonomy, is not a central tenet that arbitration stakeholders view as paramount, notwithstanding that the principle of arbitrator discretion often is cloaked with the correct and also euphemistic term, quote, the inherent powers of arbitrators, close quote. That's just another phrase, I think, both conceptually and practically, for arbitrator discretion. The term, however, does not rest from arbitrator discretion inherent uncertainty and therefore lack of predictive value. Likewise, the term, quote, inherent powers of arbitrators, close quote, does little to reconcile the need to maximize, quote, party autonomy, a principle that the fulcrum of ICA's, a principle that is the fulcrum, of ICA's better workings. Arbitrator discretion is inversely proportional to party autonomy. Arbitrator discretion is inversely proportional to party autonomy. The scant treatment of evidence taking in the rules of all major arbitral institutes is not cured by the IBA rules of the taking of evidence in international arbitration or the Prague rules on the efficient conduct of proceedings in international arbitration. The interplay between efficiency, party autonomy, arbitrator discretion, and existing institutional rules of evidence, as well as the IBA rules, will have to be closely analyzed within the framework of these very rules in order to determine whether ICA evidentiary rules can be framed to provide for risk assessment that is conducive to settlement. Obviously, my position, and I will not go through those rules in this chat, is that they can be. They can be tailored to the an analysis that and application that give rise to the identification, quantification, and then, of course, subsequent communication of risk, such that at T1 in the arbitration, arbitrators, arbitral parties, and the arbitral tribunal, the parties and the tribunal, both sets of stakeholders know the value of each party's case. It is very often that you speak to even mature and sophisticated counsel, and you ask them for the value of the case. The value of the case quantified not in terms of what damages you're seeking, but what is the risk to you of prevailing or of not prevailing if you're a respondent and facing liability. And they can't articulate it. because they haven't engaged in that analysis. And the reason they haven't engaged in that analysis is because they haven't had, ladies and gentlemen, the raw materials to engage in that analysis credibly to the satisfaction of their respective clients. Because there's been no evidence taking yet. Can the evidentiary rules that govern evidence taking and presentation be framed so as to preserve the nature of ICA while maximizing efficiency and minimizing the likelihood of a zero-sum game, a scenario where one party invariably loses? Have we really understood efficiency within the rubric of ICA? It will be suggested that the legacy understanding of efficiency in ICA only has been associated with what is here termed as process efficiency. In other words, what I am trying to suggest is that the way we've been thinking about efficiency in ICA has been process efficiency, as I call it, because we're only concerned with the efficiencies that are attendant to, endemic to, issuing a binding and enforceable award. What does that mean? It means that we contemplate efficiency always, necessarily, within the framework of a zero-sum game situation. We never think of efficiency in the context of settlement, what I call optimal efficiency in contrast to process efficiency. And there are reasons for this. Let's look at the promise to be efficient. What then is the legacy promise to be efficient? What does the historical existing material teach us about how our consciousness of efficiency works within the rubric in the context of ICA? What is the historicity of efficiency, sometimes expressed as a form of, quote, expeditious streamlining? I'm sure you've all heard of that. Within the context of ICA, it will be asserted that efficiency in ICA has been limited to process efficiency only, as I have just described. Some, but not all of these questions have answers. It is, however, demonstrable that the promise of efficiency in ICA has many, many faces. None of them, however, concern settlement. They all pertain to process, regrettably. The different faces of efficiency in ICA necessarily have to be referenced, even if ever so fleetingly, if we're to understand the various practical and structural challenges that settlement presents to the efficiency equation. I have placed before you a PowerPoint slide illustrating the Oxford English Dictionary's, OED's, definition of the word efficient. Efficient, the adjective, derives from the Latin efficientem, which has the nominative efficiens, a principle of efficiere, making its way into 1398 Old French, meaning making. The OED captures this etymology with a first entry defining efficient as, quote, making, causing, that makes a thing what it is, end of citation. That's what it says there in the OED. The second entry under efficient de-emphasizes causal connection, while still acknowledging it, but underscores lack of waste. It identifies efficiency as, quote, effective, and, quote, producing the desired result with the minimum wasted effort of a person capable, competent. Physics characterized by a high or specified efficiency, end of citation. It is, however, the third entry in the OED that I like under physics that I believe is most helpful. Please look at the slide before you, and you will note that the following definition, quote, the work done by a force in operating a machine, the total, and I've got the wrong slide up. Hold on a second. Let me see. will take it from me on a leap of faith. This, I promise you, this is what it says there. It really, quote, the work done by a force in operating a machine, the total energy expended by a machine, the ratio of useful work performed by a device or system to the total energy input, end of citation. The appropriate definition must be one that captures ratios and proportions, i.e. the relationship between ratios of proportion. The relationship between currency expended as part of the process of arbitral adjudication in relation to the amount in controversy, i.e. damages sought, is absolutely paramount. Therefore, the approach must be one that seeks to embrace and to quantify currency expended as a condition precedent to a process that must culminate with an enforceable arbitral award. More, however, is necessary. A proportion, a relationship between ratios must be compelled. Any truly serious attempt to explore efficiency in ICA must add the cost of arbitration in relation to the amount in controversy, the entire duration of the process, together with the quantification of business interruption, i.e., the human hours expended directly or indirectly as part of the arbitration process, often the most expensive part of the entire effort. Efficiency models also must account for proportionality, as we shall see, in the gathering and presentation of evidence. The entire arbitration process and then each procedural phase should be susceptible to efficiency accountability if in fact arbitration is to redeem its promise. To be sure, even a proportionality-based definition of efficiency in the context of arbitration shall require the consideration of such factors as the complexity of legal and factual issues, the particular kind and extent of technical expert testimony, the factual document intensity of the case, the number and location of experts and fact witnesses, the configuration of evidence taking, the presence or absence of counterclaims, the amenability of partial or complete summary disposition, the practicality of mediation, and the parties' resources in both relative and absolute terms. These factors are hardly exhaustive. An understanding of efficiency in the context of ICA that does not consider these basic elements, together with a proportionality approach that accounts for resources expended and furtherance of an objective over time, would be meritless. In fact, one commentator went so far as to quite rightfully observe that the OED's definition of efficiency as, quote, the state or quality of being efficient, close quote, as the historical meaning of the word, would lead to the absurd result that, quote, any arbitration that results in an award would be considered an efficient arbitration. However, perhaps this historical definition does not work well with a modern business-like approach that many parties expect from arbitration. It is not merely a matter of getting an outcome, but also of getting an outcome in a process which itself appears and perhaps also is efficient. End of citation. A comprehensive and rigorous definition of efficiency applied to ICA more often than not would demonstrate that settlement in the majority of cases most often comports with a higher efficiency rating than an all or nothing zero-sum game merits adjudication. It is virtually unlikely that a merits-based ICA adjudication yielding an award approximately 36 months after the filing of a request for arbitration can lead to an efficient result, particularly when the award is challenged and execution on an award reduced to a judicial judgment is required. So then what is the emergence of process efficiency? How did this thing get into arbitration in the first place? Efficiency in arbitration historically has been promised and assumed, but never defined, ever. Both its definition and practical application remain illusory. notwithstanding its importance as a defining pillar of ICA, together with party autonomy, predictive value, and arbitrator discretion arising from the enforceability of awards. It is virtually impossible to identify when efficiency surfaced as a principal pole star of ICA. In the United States, by way of illustration, the National Arbitration Law, the Federal Arbitration Act, was first enacted on February 12, 1925, in its initial iteration. Its legislative objective principally was to overcome 4 badges and vestiges of conceptual prejudice that judicial hostility ascribed to arbitration. First, the ousting of jurisdiction from courts of otherwise competent jurisdiction. Second, the view that an arbitration proceeding requires judicial supervision. Third, the conviction that arbitration was not well suited for administering complex domestic or international cases. And fourth, the idea that arbitration is not the appropriate dispute resolution methodology to administer certain types of statutory claims that provide defendants with rights in situations where they lacked equal bargaining fiat. Addressing these badges of judicial prejudice unquestionably constituted the FAA's principal objective. In the 19th century, the ruling of U.S. courts reflected the inherited English aversion to arbitration. In fact, the United States Supreme Court in Hamilton v. Liverpool, decided in 1890, asserted 3 precepts adverse to arbitration agreements. First, that the argument contended that an arbitration agreement does not constitute a sufficient basis on which to premise a stay of a judicial proceeding based on the same cause of action arising out of or pertaining to the agreement itself. Second, the court observed that specific performance is not a category of damages that can be awarded based upon an arbitration agreement without more. Third, it was held that the arbitration agreement would not be accorded effect as a plea at bar, quote, except in limited instances, i.e., in the case of an agreement expressly or impliedly making it a condition precedent to litigation that an award issued determining some preliminary questions of fact upon which any liability would be contingent. End of citation. Although in the early 20th century, the U.S. Supreme Court in dicta very fleetingly alluded to a possible new horizon that would construe arbitration agreements in a more favorable light with greater affinity with judicial proceedings as to standing and legitimacy, the issue was simply not ripe for adjudication in those very few extraordinary cases. The Supreme Court, however, in Marine Transit Corp versus Dreyfus, observed that at least theoretically, the Federal Arbitration Act was crafted with the intent substantially and meaningfully to alter the prevailing judicial penchant against arbitration. Even though some of the 1925 language in the Congressional Archives, now just a little over 100 years ago, is more than a shade anachronistic, it is emblematic because that language constitutes the first, foremost, and most forceful congressional pronouncement demonstrating that Congress rejected the judicial branch's derision of arbitration. Let me see. Let's leave it there. There is a House of Representatives bill. It's bill number 68. It refers to the 68th Congress, and 96 represents the report of the bill 1924. It is language that demonstrates the FAA's priority was dispelling judicial skepticism concerning arbitration that had been imported whole cloth into the U.S. Common law from the English common law. Certainly, it would not be incompatible. Certainly, it would not be a complete stretch to argue that the principle of efficiency was foremost in the institutionalization of arbitration, at least in the United States. Does this go back? Does this slide thing go back? Yeah?
Sure. Believe the right button.
Oh,
Click the left button on the.
yeah. I'm clicking it. Hold on. Let's see what I can do here. Yeah. Sorry, we're gonna have to do without the slides, I guess, because I'm just not. Don't worry. Don't worry about it. Don't worry about it. There's just something, the slides are not matching my text, so don't worry about it. I apologize for that. The language that I wanted to cite from the congressional records reads as follows, and I think it's extremely important, and it's a historical piece of data. Arbitration agreements are purely matters of contract, and the effect of the bill is simply to make the contracting parties live up to his agreement. He can no longer refuse to perform his contract when it becomes disadvantageous to him. An arbitration agreement is placed upon the same footing as other contracts where it belongs. Now, when what follows here is the language that I find more interesting. The need for the law arises from the anachronism of our American law. Some centuries ago, because of the jealousy of English courts for their own justification, they refused to enforce specific agreements to arbitrate upon the ground that the courts were thereby ousted from their jurisdiction. This jealousy survived for so long a period that the principle became firmly embedded in the English common law and was adopted with it by the American courts. The courts have felt that the precedent was too strongly fixed to be overturned without legislative enactment, although they have frequently criticized the rule and recognized its illogical nature and the injustice which results from it. The bill declares simply that such agreements for arbitration shall be enforced and provides a procedure in federal courts for their enforcement. It goes on to say it is particularly appropriate that the action should be taken at this time where there is so much agitation against the costliness and delays of litigation. These matters can be largely eliminated by agreements for arbitration if arbitration agreements are made valid and enforceable. Just think about that language, which is, I understand, somewhat prosaic. What it's basically saying is we should turn to arbitration, not only because obviously it's a contract, it has to be read and respected, et cetera, but it says now, back then, this is a long time ago, over just 101 years ago, litigation is too expensive. The irony is that now arbitration is just as expensive and in many instances more expensive than litigation. And in fact, if in some aspects of litigation, commercial cases, numbers like 80% of those cases settle, then you're better off litigating in that sense from that purely efficiency-driven perspective than arbitrating. While certainly the fulcrum for the enactment of the FAA was to place arbitration in pari materia together with judicial tribunals, the legislative evidence makes clear, crystal clear, that efficiency in contrast with, quote, the costliness and, quote, delays of litigation appears to have been underscored as material features of arbitration, warranting its promotion and adoption as a dispute resolution methodology of equal dignity with judicial tribunals. This language is more than just a marginal comment. In a Senate report dated May 14, 1924, the Committee on the Judiciary submitted the identical understanding of efficiency in relation to arbitration. Quote, it has been said that arrangements for avoiding the delay and expense of litigation and referring a dispute to friends or neutral persons are a natural practice of which traces may be found in any state of society. The desire to avoid the delay and expense of litigation persists The desire grows with time and as delays and time and as delays and expenses increase. The settlement of disputes by arbitration appeals to big business and little business alike, to corporate interests as well as to individuals. The Arbitration Society of America, with offices in the city of New York, has, through its arbitration tribunal, settled more than 500 cases during its less than 2 years of existence. End of citation. Imagine that fantasy, that number of cases having reached the end of all arbitral labor in such a short period of time. That's not even remotely imaginable today. Not even remotely, not in a Midsummer Night's Dream. Quite significantly, this congressional report is a particularly rich historical document because it goes on to cite to a contemporaneous newspaper report. Get this, quote, in the New York Times, May 11, is found a brief resume of the work accomplished, referring to a number of cases processed by the Arbitration Society of America during a mere 2-year time frame. We quote the following. In contrast with the long time required by the courts with their congested calendars to settle a dispute, the records of the society show that the average arbitration required but a single hearing and occupied but a few hours of the time of disputant, counsel, and witnesses. The cost to the disputants was said to be trifling as compared with the cost of litigation. Complicated controversies involving large sums of money, which, beyond a reasonable doubt, if taken to the courts, would have been fought through years of costly litigation, have been legally determined in this tribunal, whose only rule of procedure, I repeat this, whose only rule of procedure is the rule of common sense in the form of 2 to 3 weeks. The report that goes on to state, quote, the specially significant thing, just as significant as a saving of time and money, is the fact that wide satisfaction has resulted from the procedure. Winners and losers alike bear witness to this in letters on file at the office of the society. End of citation. It really does sound like something from another world. I mean, it's like the Martians were conducting arbitration. The testimony before the Joint Committee of Subcommittees on the Judiciary, United States Senate and House of Representatives, held on January 9th, 1924, similarly underscores the primacy of efficiency as arbitration's foundational pillar. This phase of efficiency principally, but not exclusively, is in the form of contrast with litigation. Here, there's a brief excerpt from the representative of the New York State Chamber of Commerce, who also represented Importers and Exporters Association and the Merchants Association of New York. This is one Mr. Bernheimer, and he states as follows. And again, this is what's in there. This is what this person says. The most unprofitable thing that the merchant and businessman or anyone engaged in buying and selling can have confront him is that of litigation. It is unprofitable to him, and it is unprofitable to the state, and it is unprofitable to the law office. That last one I don't understand. He goes on, speaking for those who have had experience and who are engaged in business, I may say this, that arbitration saves time, saves trouble, saves money. There is no question about that. We know it. It preserves business friendships. That's also like from another world. The usual court atmosphere does not get into the arbitration hearings. Arbitration prevents unnecessary litigation and eliminates the law's delay by relieving our courts. End of citation. Similarly, in this connection, industry representatives further testified that, quote, the objective of the bill we are very much in favor of, the objectives of an arbitration in commercial matters, believing it will be helpful in speeding business, close quote. Testimony likewise contended that while the dollar savings to businesses resulting from passing the Federal Arbitration Act could not be quantified, Julius Henry Cohen, a member of the Committee on Commerce, Trade, and Commercial Law of the American Bar Association, and then general counsel to the New York State Chamber of Commerce, testified that, quote, if you could get rid in the New York calendars, both in the federal courts and in the state courts and in congested centers through the country, if you could get rid of the litigation that these business concerns can prevent by their arbitration committees, you and I would be able to get along without important litigation, without waiting for a year or two for it to be reached. In other words, you would take out all these matters of business and leave the courts free to handle the business that ought to be handled with due dispatch. End of citation. Indeed, the early evidence contemporaneous with the passing of the FAA is simple in its aspirations based upon the principle of efficiency that was viewed as defining arbitration. In the words of a declarant memorialized in the congressional records of the House of Representatives, quote, the result of such a bill will be to do away with a lot of expensive litigation, end of citation. It is easy to be distracted by this testimony and to lose perspective. For this reason, please take a mental step back and contextualize the facts that you have reviewed and the evidence that has been proffered before you. I will call your attention to 7 propositions. First, in absolutely none of the materials reviewed regarding efficiency and arbitration did you find any reference to the term, quote, party autonomy. And this matters. The reason is simple. Contrary to what you have learned, read, or heard, it was the promise of efficiency and not the concept of party autonomy as we know it today that was represented as the hallmark and defining central foundational feature of arbitration. Certainly, the references to arbitration as arising from a contractual relationship holds out the implicit proposition that contracts are voluntarily entered into and therefore the will of the parties to include an arbitration clause is a demonstrable exercise of party autonomy. I get that. Yet the workings of party autonomy were not detailed in these early writings, and the term textually, literally, and conceptually is altogether absent. Efficiency, however, was present. The proposition that some commentators have articulated, namely that, quote, efficiency was not featuring as a typical feature of international arbitration some 20 odd years ago, close quote, does not comport with this evidence. Let me just tell you this. There are voices out there writing and stating that efficiency only recently became a pillar of arbitration. That really arbitration was the party autonomy aspect of arbitration that was driving arbitration as a popular vehicle to hold the status of pari materia of equality with judicial courts. And that's just, there's absolutely no evidence, I share with you, absolutely no evidence in the United States and really beyond that such is the case. That's just not there. You can't find the documents. Efficiency certainly was being emphasized almost 100 years ago over 100 years ago to this very date. Party autonomy, of course, is central to arbitration. The ICA's most relevant and important regulatory source, the New York Convention, certainly states as much in Article 5.1d, which reads, quote, the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. So yes, of course, party autonomy is important. Of course, it's critical. Of course, we find it in the New York Convention, but it was not one of the foundational pillars driving arbitration in its inception. Second, enforceability of an arbitral award, the single most important feature of ICA, nowhere is mentioned. A legitimate counter-argument to both the absence of party autonomy and enforceability as salient elements of ICA in the FAA's legislative history can be attributed to the absence of an arbitral enforcement regime, a time frame that predated economic globalization by approximately 60 years. While these two premises do have a surface seductive glitter, however, they do not resist sustained analysis. The International Court of Arbitration of the International Chamber of Commerce, the ICC, was founded in Paris in 1923, and the International Chamber of Commerce in 1919. Moreover, the Permanent Court of Arbitration, the PCA, was established in 1899 by the First Hague Peace Conference under Articles 20 to 29 of the 1899 Hague Convention for the Pacific Settlement of International Disputes. So there goes that historical argument. Hence, the seemingly ubiquitous reference to efficiency as a foundational arbitral precept, in contrast with the paucity of outright explicit references to party autonomy and enforceability, cannot be ascribed to the embryonic status of the ICA in the first quarter of the 20th century. As for the proposition that the FAA primarily concerns itself with domestic arbitration, and for this reason somehow it emphasized efficiency and minimized party autonomy and enforceability, the congressional records addressing the amendments to the FAA indisputably suggest otherwise. Even though the FAA was first enacted on February 12, 1925, it was not codified until July 30, 1947, and amended on September 3, 1954. Critical to this analysis, however, on July 31, 1970, Chapter 2 was added, which incorporated, without any revision, the entirety of the New York Convention. Similarly, on August 15, 1990, Chapter 3 was added, namely the Inter-American Convention on International Commercial Arbitration, which is an instrument virtually identical to the New York Convention, limited only to the recognition and enforcement of foreign arbitral awards. Quite remarkably, the congressional records concerning the incorporation into the FAA of these two enforcement frameworks underscores efficiency as ICA's cornerstone. The materials pertaining to the New York Convention's wholesale incorporation to Chapter 2 of the FAA includes a presidential letter of submittal dated April 18, 1968. That correspondence I share with you in relevant part reads, quote, the recommendations for U.S. accession to the convention, the New York Convention, of course, recognize the continually increasing importance of arbitration as an efficient, expeditious, and inexpensive means of resolving disputes that arise between private parties in carrying on international commerce. They also underline the importance which the convention has assumed in ensuring the carrying out of arbitration awards in cases involving persons of different nationality. End of citation. I can, and I will not do it because we are pressed for time, and I do want to keep my promise to you. But I can cite to a lot of authority that substantiates this point, that it's efficiency, it's not party autonomy, it's not even the enforceability of international arbitral awards that drove the initial strength of impetus that arbitration has. And it's that type of efficiency that's what we inherited. That's the efficiency that goes into play. And when you hear about incorporating efficiency into arbitration in seminars, books, lectures, everywhere, what you talk about is streamlining the process, not having cross-examination in the final hearing, things that are really mind-boggling, because if you break them down, you'll find that these elements of streamlining the process or not having as much evidence gathering, none of those things really lead to substantial and material inefficiency. I dare say the greatest inefficiency occurs with the arbitrators, and I serve as an arbitrator, and I live from arbitration. Arbitration is what I love; it's my passion. But the greatest inefficiency really arises, from what? The arbitrators taking too long to issue an award. The arbitrators not furthering and encouraging settlement. The arbitrators not mismanaging the evidence-taking process. This is where all the real inefficiencies in arbitration take place. In the arbitration, in the world of inefficiency, of process inefficiency or process efficiency. These are the things that concern efficiency only within the rubric of issuing a binding and enforceable award. But that's not the real efficiency. I just want to touch on the final 3 points that I want to make in this connection. Fifth, you will I also ask you to consider that time and resources demands on witnesses, counsel, and parties was referenced as a metric of efficiency. So it's all process efficiency. You see that. 6, having one hearing only was underscored as an element of efficiency. Again, process efficiency. There's no talk about settlement. There's no talk about resolving the dispute. 7th, and finally, reference was made to having, quote, common sense, close quote, as the only rule of procedure and therefore also a metric for the promise to be efficient as a salient normative feature of arbitration. While efficiency within the arbitral context has not been defined, 2 general categories stand out: quantitative savings and qualitative process management. Although these 2 categories can be identified with bright line distinctions, they are profoundly related. Both concern what we have coined as process efficiency. In closing, guys, ICA can redeem its promise to be efficient. To do so, however, it must pursue parallel objectives in tandem. ICA, of course, must continue to concern itself with a dispute resolution methodology that will culminate yielding binding and enforceable awards. This imperative must be pursued together with the objective of maximizing efficiency pursuant to settlement. 2 objectives to be treated in pari materia. To do so requires adherence to a number of principles. And I can talk to you about these principles also at length, and I ask you and invite all of you to please, feel free to call me, and we can go over them. But mostly what these principles concern themselves with are, again, using rules and having rules that make possible an understanding of each party's evidentiary position early on in the proceeding. That is what is most critical, so that there can be complete transparency. This transparency in turn will yield to the type of risk assessment that will be helpful to settling disputes. The only way that it can happen. And of course, what I'm talking about here, these challenges are indeed difficult. This road is steep and rife with obstacles. Some of these obstacles seem virtually insurmountable because they concern embracing a new culture of arbitration. Those are the obstacles within oneself. It remains less than clear whether we have the intellectual courage to help arbitration redeem its promise. Thus, I leave you with a scene from Ovid's Metamorphosis, of all things and places. There, Aeneas confronts an armed spirit standing before the entrance of the netherworld. Aeneas asks the guard whether, in the name of a son's love for his father, Aeneas may be allowed to visit his father's spirit in the land of the dead. The armed angelic guard heeds Aeneas' request and says, quote, Aeneas, you are a man of valor and honor. More than once have you risked your life for just causes and in defense of the most needy. Of course, I will let you visit your father because, and he says, nulla via in via virtuti est, for virtue, no path is invincible. Now, I know that if any generation, if any group of human beings has a chance of overcoming these obstacles and improving on what we have, I am looking at them today. And for this, I want to thank you. And if you have any questions, we can, discuss them. Yes, sir.
I know nothing about this, but first, congratulations on your forthcoming book and the Hague lectures. That's really great. I hope some of the books will make it to our library so that we can.
I'll make sure to send them, even though they're only good. They're only good for sleeping. You know, if you can't sleep, you open them, you read them, and you know.
No, they're better than that. But I found this very provocative, and your idea for the arbitrators to engage in this signaling very early on in the arbitral process to assess risk so that the arbitral process is efficient, it doesn't go on forever, and perhaps settles. But it raises two questions for me. The first one is, and I'm not defending the whole system, I don't like it. I imagine some parties would say that they would like the full benefit of an evidentiary hearing to make sure that the tribunal has had on the merits the arguments, and that they brought their damages experts so that the risks that the investor has suffered can be evaluated fully. So I wonder how you respond. Those are due process questions and the traditional framework. For people that might be skeptical of an early settlement where the tribunal also may take on a more inquisitorial role than is traditionally the case. I wonder about how you might respond to that. The second is, I think, as you were ending, you emphasize this is really about making the process efficient. At least on the ISDS side of the ISDA, I am skeptical that process reforms are sufficient to address the most structural questions, such as, at least in the ISDS context, the fact that only investors may sue and states cannot. The whole debate about what to do about climate change in light of the very big questions that arise when disputes are filed, challenged, and environmental regulation. So sort of just wondering aloud how you might respond to some of those concerns that have been part of the conversation about this entire process.
Well, first of all, thank you for your observation and question. You know, it's a compound question, but it's an excellent question. I think first I'd like to contextualize any answer. Today, arbitration is in a crisis. There's a lot. This lecture really is a 5-day, 2-hour-a-day lecture, and I've abbreviated it significantly. That's why I didn't go into numbers and all that. But one of the things that I can demonstrate to a moral certainty is that corporate America is losing its appetite for arbitral services, and going back to choice of court agreements, that just going back to international / private normal litigation to air disputes in courts, and finding international arbitration extremely expensive and extremely problematic. I'll leave the ISDS to one side, but I will address it. If parties want to engage in an evidentiary hearing before settling, I will tell you that that's conceptually possible, but practically speaking, it's not going to work, because by that time, so many resources have been expended, and at that time, you've rolled the dice. So what you're really saying is, let's go all the way to the end. Let's wait the 3 years. Let's expend the millions of dollars. Let's have the business interruption, and then let's go through a hearing that can cost any amount of money that you can imagine, depending on the facts. And then right before that award comes out, now finally we're in a place to assess our risk. I would venture to say that would be a paradigm of the most inefficient form of settlement. Short of standard process inefficiency, which is just go the whole way and there'll be a winner and a loser. I think that it's now common, or it's becoming more common, for there to be conceptual buy-in into the proposition that parties want the tribunal to tell them how they're seeing the case at an early stage to promote settlement. And parties can control whether they want the tribunal to tell them that. And the president of the tribunal, she can say, look, the way we're seeing the case now is X, Y, and Z without prejudice to more evidence coming in. You know, there's something that we forget about, especially here in the United States. In the United States, we have, of course, you know, pretrial procedure. That's because when we file a complaint, we're not in trial, we're in litigation. But evidence is not being taken. But you know what we miss sight of? When we're in arbitration, ladies and gentlemen, the second you file that request for arbitration, and the second that any evidence is requested and issued, you're in the final hearing. At that point, the arbitral tribunal is already assessing relevance, admissibility, materiality, and the only thing that it's not assessing is weight. And it may already start assessing weight. So relevance, admissibility, relevance, and materiality, and weight, those four elements, which are so basic, that's being assessed at T1 in an arbitration already. So what I'm really saying, and what these voices that are calling for settlement and arbitration are saying is, look, let's just use the very structure itself to the extent that we can to start thinking about settlement and arbitration in a constructive way. Now, the ISDS is a separate dollar bill altogether. ISDS cases rarely settle. I'm not going to say they never settle. I've had cases that have settled, but they rarely settle. But there are elements that we can't control, the political aspects. States cannot settle sometimes for political reasons, and they want that problem to be inherited by another administration. Asking a state to say, look, you know, issue a press release saying that we settled this case for a mere $200 million when child mortality, caloric consumption, life expectancy are all south of what they should be, is not a politically viable issue. So you leave it and you delay it and you punt on it and you let another administration handle it. Do I feel that otherwise settlement in an ISDS is possible? Yes, I do. But it's the same thing. You need the management of evidence has to take place at a time that allows the parties to identify, quantify, and communicate risk. Without that, you cannot settle a case responsibly. I know I didn't answer your questions, but that's the best I can do. Yes, sir.
One concern when it comes to the ISDS and interstate arbitration process is the rather small pool of arbitrators and the sort of like repeat players and repeat roles that those individuals have, which raises certain questions of biases, especially given where those individuals tend to come from. When we're talking about amplifying the role of arbitrators to encourage settlement and to help quantify, communicate, and identify these risks, when the evidence might be lower, or like there might be a reduced quality in evidence, for me that would raise a concern of, are we then furthering the sort of concerns and biases that we already have about arbitrators?
What's your name?
Colin.
Sorry?
Colin.
Colin, that's an excellent question. Let me just say two things about the problem with one of the challenges we meet. There's a horrific problem with arbitrators in arbitration. That's a big problem. And let me give you objective, not anecdotal, objective data that will help. In the history of ISDS arbitration, I'll say it twice. In the history of ISDS arbitration, only in 2 instances has a dissenting opinion been written by the arbitrator that has not been appointed by the non-prevailing party. Do you understand? That means that, I mean, that's mathematically almost impossible if you are talking about a system where you have two neutrals and the president is also completely neutral. So we know that the dissents, the separate opinions already bespeak some sort of partiality, irregularity. That goes both ways, not just the person writing the dissenting opinion. Well, what about the other person? What about the other? How often does an appointed neutral say, no, the party that appointed me is wrong? And by the way, what's wrong with that? If what we want is integrity. Also, there are arbitrators in the market, and I'm not going to name names, that's not necessary, nor professional, nor appropriate. But there are arbitrators in the market who find for states. Who just find for states. They have a long history, and in every case they sit, it happens that the state wins. Or they side as a matter of public record with the state in a where the state doesn't win. But they've never found for a claimant, ever, in their long distinguished histories. That's conceptually and mathematically impossible absent partiality. It's just impossible. It cannot happen. Cannot happen, but it happens. This is amply documented. The most important, and I'll just say this because we're in a classroom, and I want you to know this. If nothing, you forget about my entire theory, everything I've said here, but I want you to know this one thing. The most important part of an arbitration is the selection of the arbitral tribunal. There is nothing more consequential that you can do than selecting the arbitral tribunal. Forget about everything I said. Just remember that, and then today's investment in here was worth it to you. So what am I saying to respond to your question? I don't want the arbitral tribunal necessarily assessing the facts and telling the parties where they are. That's one approach of many approaches towards settlement. I believe in party autonomy. I want the parties to know where they stand, to be able to assess risk. The only thing I want from that tribunal is for the tribunal to have the vision to give both sides the evidence relevant to the case, material to its outcome, which is, again, it's a standard, the only standard we have. It's not defined anywhere, by the way. That's one of the issues that I talk about in the book. And just like there's no cross-examination in any of the rules for international arbitration, the IBA rules don't talk about cross-examination or direct examination. The IBA rules talk about testimony and direct testimony. The word cross doesn't appear anywhere. It's testimony. The emphasis is on the speaker, not on the examination. So I want the parties to figure that out and to communicate it between and among themselves. Now, do you have rules that will allow for you to have the evidence you need early on in time? I'm not sure about that. Is this possible? Do you have the right timing? I'm not sure about that. There are embryonic signs that this is workable, but right now we're not there. We just simply aren't there. Also, can we think about efficiency in terms of settlement? If you look at the historical papers on arbitration, you know what you find? The concept that you will have a dispute, you'll submit it to arbitration, and you'll go to arbitration, and then we'll continue in business together, which makes a lot of sense. Because it makes a lot of sense that you will not, break up the business. Now you have a competitor that people who already know the business and working will continue. All that makes a lot of sense. The arbitration we have today is totally denaturalized. So you're right. The arbitrators, there's a problem with arbitrators in arbitration, but we can circumvent that problem in the context of a culture of settlement. Yes, please.
Thank you so much again for joining us. I have a two-part question on the risk assessment that you mentioned. Who should be conducting this risk assessment in your opinion? Would it be the parties themselves, the tribunal, maybe like a neutral third party? And then at what stage should that risk assessment be conducted? And then the second part, I guess, for that question is, how do we in this model guard against an asymmetric risk assessment where one party has better resources and information that's just unavailable to the other party?
It's three questions. Okay. First of all, there's no one answer on who should conduct that risk assessment, so long as each party is involved. It could be a mediation situation. That's perfectly fine. It makes a lot of sense. and you can have the mediation early on. So that I don't think is important. What's important is that you have the materials early on to do it. And look, if you think about it, already Article 2 of the IBA rule says that the arbitral tribunal may, it's not, you know, it says they should. It's not in the compulsory, it's in the permissive. The arbitral tribunal should identify for the parties issues that it considers to be relevant. So what's your other, let's leave the asymmetrical last. What's your second point?
At what procedural stage?
Early.
does this become-
The earliest. Otherwise, we're back in the rat race of just spending money and not engaging in procedural process efficiency, which it's just gonna do what it's doing, causing causing arbitration to have process legitimacy questions. And asymmetrical knowledge, the parties need to know, if you have an asymmetrical access to documents, then you can't have settlement by definition. It has to be symmetrical. And no system can fix that for the parties. You have to get your documents. But that should be rather easy. That should be rather easy, that there are rules that should help, because if there are rules that say that you have to disclose, for example, the basis for your calculations for your damages and the actual evidence upon which those calculations were based, that goes a long way. For example, that's just one example, but no, it cannot be asymmetrical. Professor Moses.
Thank you very much for this lecture. I think it was very helpful in helping us all sort of think outside the box. But some of us may be stuck in that box a little bit. And I was wondering, you said that I think that rules could be framed to permit the possibility of settlement. They would be framed to permit identification, quantification, and communication. I wondered if you could just give some examples of what those rules would be.
Absolutely. Causing the evidence gathering to take place early in the process. And providing deadlines for that process to take place. That's not complicated, and it would fall within existing structures. As I said, Article 2 of the IBA rules already has some sort of a suggestive framework for something similar to that. Causing voluntary disclosure of evidence. Again, we already have in Article 3 of the IBA rules some grounding for that. So I think if the tribunal is sensitive on self-disclosure early on and targeted self-disclosure that goes to liability and damages and defenses, which again comports with an aspirational premise in Article 2 of the IBA rules, then I think it's pretty simple. Very simple. I want you to exchange all your evidence, including A, B, C, D, and E, by this date. And I want you we can have a conference thereafter. Well, listen, thank you. It was a privilege to meet all of you and to have this discussion. Feel free to call me, write to me if you want to continue the dialogue. And be well. Thank you.
Thank you. Great. Great questions. Excellent work.
Well, the next generation of arbitrators here.
Well, Professor Moses.
We took a few pictures of the lecture on people.
Oh, okay, thank you. Thank you. I can't do much weight.
Yes, you might.
Oh, great. International trade left. I'm thinking, like, how am I gonna teach this stuff,
No.
because